So now the oath can be administered, court assistant.
Yes.
So the witness, good morning, witness.
Morning, Your Honor.
So you will follow what the court assistant will lead you through. You are now going to take an oath for purposes of this process. Court assistant.
Okay.
Yes, you will repeat after me.
So what holy book are you using?
All right.
You have a holy book, isn't it?
Yeah, I have a holy book, yes.
Yes. What book is it? The Quran?
That is the Quran.
Thank you.
So you will repeat after me. When I tell you say hi, you mention your full names there. Say hi, Nadhif. Mention all your full names there.
All right, okay.
I,
Nadhif Jama'a Adam.
I swear in the name of the Almighty God
I swear in the name of the Almighty God
that the evidence I shall give before this court
that the evidence I should give before this court
touching the matter in question shall be the truth, the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Yes, Your Lordship.
Very well. So you can guide the witness to introduce himself, then you will submit him for cross-examination by senior counsel.
Yes, Your Lordship. Thank you. Mr. Nadhif, introduce yourself, your name, your designation, and what you do for work.
Your Honor, my name is Nadhif Jama'a Adam, the current governor of Garissa County.
You are aware the reason why you are before court today?
Oh yes, I'm fully aware why I'm before court today for cross-examination on my affidavit signed on 30th of March.
You're also aware the proceedings before the court up to this point?
Yes, I'm fully aware the proceedings before the court.
And you confirm that replying affidavit is your affidavit and has your signature?
Yes, I confirm that this affidavit is my affidavit. It has my signature.
You also confirm the annexes to the affidavit, which are about 68 pages?
I do confirm the same, yes.
My learned friend, Senior Counsel Kanjama, will ask you questions. You will answer him, then afterwards we will do re-examination of the same.
Okay. Well noted.
Nadhif, good morning.
Morning, Senior Counsel.
I will start by asking you some preliminary questions. You confirm that this affidavit of 30th of March was sworn by yourself?
The affidavit of 30th March, yes.
And you swore the affidavit in reply to an application for contempt?
Yes, correct.
You are aware that 2 applications for contempt have been filed in this case?
What I'm aware is the contempt for reinstatement of the staff, and I follow that.
Your Lordship, before Alana Senior continues, instead of confusing the witness, Your Lordship, you are specific that we are dealing with the contempt application dated 13th December, and not any other application.
There's a lot of interference. What is happening?
It's echo.
Yes. So proceed, counsel. There's a lot of echo.
Mr. Nadhif, you're aware of the application for contempt dated 13th December 2022?
Correct, yes, which is the one I'm responding to, yes.
And that the application for contempt is seeking to have you cited for contempt for disobeying a court order of 7th of December 2022. You're aware of that?
Yes, that's what, yes, I am aware of that.
You are aware that before you filed your application, your replying affidavit, there was a second application of contempt filed on 28th of March 2023.
Counsel, my current response and affidavit is based on the 13th of December.
Okay, thank you for that answer, but please listen carefully to my question. Are you aware of a second application for contempt dated 28th March 2023?
Yes, I'm aware.
Are you aware of court orders dated 14th December 2022, 10th January 2023, 26th January 2023, 14th February 2023, 2nd March 2023, and 23rd March 2023 in regard to this case?
My particular response of today and affidavit, Counsel, is based on the one of 13. And I've not looked into those particular ones in terms of responding to them.
That's okay. The question I'm asking, and please be careful as you listen to my question. Are you aware
Counsel, senior counsel, you can make it a little bit more digest so that you can deal with one order at a time so that the witness can follow. Yes.
Okay. Thank you, my lord. Are you aware that the court issued an order on 14th December 2022 in this case?
Yes.
Are you aware the court issued another order on 10th January 2023 in this case?
Correct, yes.
Are you aware of an order dated 26th January 2023 in this case?
Affirmative, yes.
Are you also aware of an order dated 14th February 2023 in this case?
Yes. Yeah, you're correct. Go ahead.
Are you aware of an order dated 2nd March 2023 in this case?
Yes.
And finally, are you aware of an order dated 23rd March 2023 in this case?
Yeah. Well, I'm aware of all the orders, Counsel, but the point I'm trying to raise is...
Very well. No, it's okay. It's okay. You've answered my question. Thank you. My next question, Governor Nadhif.
Yeah.
You are aware that all those orders requested the aggrieved county employees to be paid their outstanding salaries?
Well, those the orders, the different orders you mentioned were having different requests on the county government. But what I want to say...
That's correct. I'm asking about one specific request because I don't have much time. You are aware that among the various orders given, one consistent order was for payment of the salaries of the staff.
And in one of those orders, we complied, yes.
Okay, very well. And you complied with one order and facilitated payment of the salary for October 2022. Is that correct? Governor Nadhif, you have told the court you complied with one court order. You can confirm it was for October 2022? Nadhif, you've informed the court that you complied with one of the court orders, and I want you to confirm it, the court order to pay the salaries for October 2022.
Yes, I confirm.
And you confirm that you organized for that payment through a facility that you have with KCB Bank.
I can't remember that. I can't recall that. I mean, that is a matter for our HR department. But I know we complied with that consent, or rather with that order, on the basis of a consent that was agreed upon between the parties.
And you confirm that the salaries that you pay to your staff, you have a facility with KCB Bank to ensure that your staff receive.
It's not a facility as such. It is basically those are arrangements that counties have with banks if and when need arises. There's no such a facility as such.
And thank you.
Hello?
You confirm that based on those arrangements, you are able to pay staff salaries even as you await for the disbursement from National Treasury.
It's not, I can't confirm that, Senior, because those are not permanent arrangements. Then we may fall on them depending again on what the bank may want to do in terms of their requirements. There's no fixed or permanent arrangements like that.
Okay.
Those are need-based and they can be complied with or they not be complied with, yes.
And the staff who are working for the county have been paid their salaries until which month?
All legitimate staff who are in the county legitimately employed or procedurally employed are getting their salaries. I do not exactly know. I think the last month, of course, I think it was in March, if I'm not wrong. Yes, April was also paid, correct.
So the staff that you call legitimate have been paid November, December, January, February, March, April, and right
Correct.
now are getting their pay for May. You confirm that?
We are waiting for May, again, depending on the exchequer releases, correct.
While the other staff that you do not consider legitimate have not been paid for those 7 months. You confirm?
We paid for October as per the consent agreed upon, and that's all. And that was based on consent. It was not necessarily based on them being rightfully employed or being rightfully staffed. They were paid them with due respect and regard to the court order and out of goodwill. We are still where we were, that we are rejecting those as being not properly staff of the county.
Okay. And when you say we paid them, you gave the authority for the payment to be made in the month of October. Is that correct?
Yeah, out of the consent again, and under the court, yes, the court consent.
So if they were to be paid for another month, it would require your authority for the payment to be made. Is that correct?
Not necessarily. I mean, this is a matter in court, Wakili, Senior, this is a matter in court, and this is a matter still in court, and my affidavit in front of you explains exactly my position. We are not taking those staff on board right now. We have issues with having them on board and paying them. Yeah.
You say that as the ultimate person responsible for service delivery to the people of Garissa, you had to make a legal and sound decision informed by relevant provisions of the law and best practice.
Yeah.
You confirm that you have the ultimate authority in regard to payments in Garissa County.
Well, look, again, depending on the circumstances and the law and the issues involved. If as the ultimate, authority doesn't mean that I also undertake illegalities. As far as we're concerned,
okay, very well.
Those staff were irregularly employed, and that's our position. And it will help if you can go through my evidence.
So your position is that you have decided not to comply with the court orders because you think they were issued in vain. Is that your position?
No. What I'm saying, please read my sentence together. What I'm saying rather here is that the court was misinformed by non-disclosure of material facts. And that's our position. And it still remains our position that actually there has been a lot of misinformation, a lot of non-disclosure of material facts to the court, leading to those orders.
Okay, very well. And finally, before I conclude,
yes,
You confirm that those staff who the court has asked you to pay have been verified by the County Public Service Board as employees of the county.
No, I'm not confirming that. In fact, if you read my point number 25, you will see that the Public Service Board itself actually has been revoking their authorities to employ those staff. Please read paragraph 24 and 25 together. The board itself have been having problem with those.
Very well. Thank you. You've answered my question. You confirm that those employees were on the payroll before you took action to remove them from the payroll.
Yes, they were there, of course, yes, but we found them to be irregularly employed. That's why we moved them.
Okay. Thank you.
If I can refer you to paragraph 24, and the annexures there, whereby the board itself, from 2018 all the way to 2020, were writing between themselves that the employees are being employed illegally, that there were illegal employments, that there were irregular employments being undertaken. The board itself have been complaining. The county secretary writing letters to between themselves and to the departments. They are all attached there. So the employments were done irregularly. And when I first took office, when we took office through my acting council at that time, we wrote the board to give us the way or the procedures through which these employees were employed, and they failed to respond, and they still failed to respond. Up to now, I want to tell this honorable court that if today the employees were, if the board was asked today to produce how the evidence of how these people were employed, they can't produce them. They do not have any adverts for them. They do not have any job, positions for them in the departments. They do not have any budgets for them. They do not have any shortlistings for them. So when we say these were irregular employees employed, even against the advice of the board secretary himself, that is our position. Therefore, they still remain irregular people in the county.
Has that information that you've availed before, has it been provided? Has it been denied by the board?
We have asked for that information, and it's not there in front of the court. If that information, Your Honor, if it is there, should be given to the court, honorable court. Such information has never been given to the court in terms of how they were employed. Hence, our belief that the orders were given out without proper information being given to the court.
So it is your belief that when these petitioners came to court, were not employees at all, for them to benefit out of this order?
Of course, yes. They could not have been employees without having followed the due process. What I want to tell the court is that we are a country of laws, a country of systems and procedures. There's a way how people are employed in the country. You can't just have people the payroll straight away and expect to earn a salary. That's irregular, and that's where our position remains, that these were irregularly employed people, and the board themselves have been confirming that.
My Lord, allow me to object to the line of re-examination on two grounds. One, my colleague is asking leading questions of the witness. The last question was a leading question. And second, re-examination is going into matters not handled during cross-examination, which is contrary to the rules of re-examination.
Your Lordship, as counsel for first responded had stated, these are special proceedings. Actually, as I responded, we are supposed to also cross-examine, if anything. So therefore, my learned friend had asked those questions. And paragraph 26 was specifically.
My Lord, I think I didn't indicate that. Abdiaziz is putting words into my mouth, my Lord. Well, let's follow the rules of procedure here.
Your Lordship, as my final question.
So, Mr. Abdiaziz, the exam.
Yes, my final question. The prayers by the
Mr. Abdiaziz.
Yes, Your Lordship.
The exam be restricted to the issues in the cross-exam.
Yes, Your Lordship.
And within the rules. You know, those leading questions, Counsel, you know the rules. Now, so witness, do you have any other question?
The witness who was explaining to the reason why he has averred this paragraph 26, and I only ask, and I will ask again, why he strongly believes in this paragraph 26 on the issue of the orders being obtained out of non-disclosure of material fact. He can explain to the court, and he's been asked about that question. And I believe, Your Lordship, you have recorded that, and he has very elaborately explained.
Just put
why
the question, Counsel. Don't explain. Put the question to the witness. It is his time. Put the question. If you don't have a question, we release him.
Yes, sorry, Your Lordship, you've been asked about this paragraph 26, and it is your averment. Why do you believe strongly that these petitioners were not employees and the orders were obtained out of disclosure of material facts? Explain to the court.
I mean,
Your Honor, I disclose, Your Honor, I object to the question. The question is seeking the opinion of the witness, and the witness has said is not an expert on the question of the law. So he cannot now give his opinion on that matter, which is a legal matter.
The Lordship, it's not a matter of opinion. This is his paragraph, averment. You questioned, the counsel questioned him on the issue of non-disclosure.
So what is the question, Counsel, again?
The question is why he believes that the orders were obtained out of non-disclosure of material facts.
What is the answer?
His answer.
Well, that is the answer, Your Honor. What I'm saying is that we are, as a senior citizen of this country, as a leader, I respect the rule of the law of the country, and I will never reject a court of the order honorably given by the court. But what I'm saying here is, in this case, the orders were given out of non-disclosure of material facts to the court. That position is clear, Your Honor, and my response to that question is based on the facts and the attachments and actions I've made in my affidavit. And I want this honorable court to really appreciate where I'm coming from as the head of the county. If the councils representing the employees are worried about 1,300 or so employees to be returned back to the payroll, let them worry about the hundreds out there whose rights also have been infringed by salaries being given out to people who are irregularly employed or irregularly put in the payroll.
Your Honor, I object to that submission, which is now argument of opinion, and it is not a response to a factual issue.
It's factual. What do I know is factual? I'm talking about facts here, senior counsel. What I'm please again go through my responses.
So, Counsel, that is all?
No, Your Lordship, he was also referred to paragraph 17.
You just have a few minutes, Counsel. So how many more minutes do you need?
Paragraph 17, he was referred to paragraph 17 of the...
Mr. Biaziz, how many minutes do you need?
5 minutes, Your Lordship.
You have only 3. You know, this time must be managed. So can we just go to the issues and we move out of it? So
paragraph 17, you were asked about the team of experts.
The team of experts, Your Honor, here is the State Department, the DPM, Department of Personnel Management, which is an established department from national government. What I want to mention here is that the national government and the county governments work together where need be. They interrelate, they cooperate. We sought their support and help in this matter, given that the board was not cooperating. And when they did their report, what we found out, or what the report has said, is all there, and we have made attachments accordingly.
Mr. Abdiaziz, put the question. We can use the time.
Yes, I'm asking him about the final prayers to the court. What are your final prayers to the court, Your Excellency?
My final prayers to the court, Your Honor, is that in the interest of justice and fairness, I request this honorable court to dismiss the notice of motion dated 13th December, with the costs as a threshold for one to be cited with contempt has not been established, particularly given that there is a lot of information that has been hidden from the court. Number two, I pray to the court to find the second, third, and fourth respondents in favor and hold the second and third respondents in contempt of court, are not in contempt of the court orders, and dismiss the instance application with costs. Those are my prayers, Your Honor.